So, Richard, I can understand why Ben Roberts-Smith would have wanted to run this case, but why wouldn't his lawyers, once they saw the evidence in the discovery process, talk him out of it or try and talk him out of it?
Who knows what happens behind closed doors, Peter? They might have tried to talk him out of it. Of course, we also don't know the way in which the evidence unfolded. We don't know at what point they became aware of what witnesses were going to say. This doesn't look like a case that was decided on documents. I think it was decided very much on evidence, on verbal evidence given in court. So they might not have had a lot of notice as to what was coming.
But the lawyers surely, would you have said, if you were running this, would you have said to Ben Roberts-Smith, you're rolling the dice if you go to court?
I think that's the advice you have to give to every defamation plaintiff. I mean, it's always said that when you sue for defamation, you put your whole life and your whole reputation on the line.
Yeah. So in this case, he's been accused by Nick McKenzie and Chris Masters, two excellent journalists, of, as we know, murder and war criminal, amongst other things. He could have shrugged his shoulders and said, oh, that's just the media, and got on with life, and the world would have forgotten about this. Obviously, there's other stuff going in the background to do with investigating war crimes elsewhere, but the world would have moved on.
I think that's right, and that is one of the things that, again, a defamation plaintiff or a potential plaintiff always has to bear in mind, that by the time you get to court, if you're lucky, a year and a half has gone by. For him, it was much, much longer.
I was in a similar situation many years ago, and a barrister, he later became a High Court judge, Ian Callanan, and I were walking to court in another case, and I said, why is this bloke continuing with this? Because our case is so strong, he's almost certain to lose. And the thinking we thought was, I've given so much to this country. How dare they accuse me of doing the wrong thing, even though he clearly had done the wrong thing? And I can see the similarity here. Can you?
Absolutely. I mean, if you imagine what it would have been like for his lawyers when he walked into their office on day one, here we have a hero, our most highly decorated living soldier, who's being so recognised and so rewarded. And if he came in and said to you, look at what they've said about me, these are all lies, it's not true, I am a hero, I have helped save this country and save Western security, to help defend Western security, and so on and so on, I can imagine that being very compelling.
I know civil cases are balance of probability, not beyond reasonable doubt. But it's not in this case where it's a serious offence, it's not 51%, is it?
No, that's right. I mean, the balance in some cases, if you can tip the balance, as you say, 51% versus 49%, you've tipped the balance and you've established something on the balance of probabilities. But there's a principle which is named after a case called Briganshaw, which says that the more serious the allegation, the more sure you have to be, the more sure the evidence has to be. So the balance is a balance that approaches beyond reasonable doubt. And Justice Bosanquet would have been very, very alive to that, because it is difficult to think of more serious allegations than these. To call a soldier a war, particularly a hero, a recognised hero and a decorated hero, a war criminal and a murderer, it is hard to think of anything more serious. So the judge would have had to have been very, very sure.
So if there's a sliding scale, he would have been very close to beyond reasonable doubt, not
yes.
The balance of probabilities.
Yes. He would have to have been. And the case law is very clear on that. And I would expect when we see the judgment that he will talk about that and explain why he is so sure. And so it's because there are so many witnesses who said the same thing. It might be because he says that he found Roberts-Smith unconvincing in the witness box. Who knows?
Okay. Would Ben Roberts-Smith have had a better chance if it had been a jury trial? So it would have been something of a celebrity trial?
I think it might have been. I think that the considerations that I was talking about earlier of a man who's a national hero, who's been awarded a Victoria Cross, if you decide that he's telling the truth, then you might keep believing him. Sitting on that jury, you might have kept believing him, regardless of how many witnesses were called to contradict him. And it is possible that Justice Bosanko could have gone through the same analysis. We don't yet have the detailed reasons to know what it was that Justice Bosanko relied on to conclude that he didn't believe Ben Roberts-Smith, and he did believe the many other witnesses. It might be the number of witnesses, more than 40. It might be their demeanour in the witness box. And with a decision by a judge, we get the reasons and we will get to see what was in the judge's mind. With a jury, all we would know is yes, the imputations are defamatory, and yes, the defence of truth is made out, or no, it is not made out. You don't get any reasons, and it's hard to appeal against a jury verdict as well.
Well, also, I know the institution of the courts is trusted better than most other institutions, but it's not universally and completely trusted. In a jury trial, if he'd got guilty, as you know, they'd found that he was a murderer and a war criminal, again, he could have spent, provided nothing else happened in his life, he could have spent the next few years saying, yeah, but the bloody jury got it wrong.
Yes.
That's the problem with juries,
yes,
etc. So everybody's against me, but I'm still a war hero. He can't do that now that there is a comprehensive judgment, and I believe this judge is very good at issuing opinions that is going to be there forever.
He may be able to appeal. His lawyers have asked for an extended period to consider their rights of an appeal, and you can be sure both sides will pour through the judgment, go through all the details, and see what they can find. But it is notoriously difficult to overturn a finding made by a judge who then gives reasons, who has the benefit of seeing all the witnesses in the witness box and forms a view about who they think is truthful and who they think is not. And the court of appeal will always be reluctant to say, we can decide, reading the transcript, we can decide better than the judge could have decided, having, who had the benefit of seeing the witnesses.
Well, the other thing that goes through people's minds whenever this happens is the only people who make any money out of these things are lawyers. So that's a factor too.
I think it is, and there are all kinds of dollar figures swirling around at the moment, but I think very conservative estimates say the case has cost at least $25 million. Personally, I think that's probably light on. The trial ran for well over 100 days with some of the most eminent senior counsel in the country. Some so senior they retired during the case.
So we've paid for a number of lawyers' tennis courts.
Probably.
Yeah, okay. Richard, Leder, thank you very much.
My absolute pleasure. Great to see you.